Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. If policy whiplash and mounting caseloads are draining the joy from your practice, you're not alone. You became a lawyer to help people build new lives, not to drown in paperwork and rework cases amid shifting political winds. That's why the experts at e-Immigration by Serenade created the Certainty Factor, a free guide showing how purpose-built AI tools can create stability in your practice without sacrificing the human touch. Featuring insights from top innovators in immigration law, Serenade is sharing ways to implement AI so you can be a strategic advocate again. Download the Certainty Factor today at get.eimmigration.com/certainty and put the heart back in your practice. That's get.eimmigration.com/certainty or click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. It was a wild week of cases. As you'll hear time and time again this episode, the Attorney General and the BIA went insane. Literally insane. It is accordingly a 9-case week. We don't get many of those, thank God. And it was going to be all negative until the D.C. Circuit came in big twice on Friday with 2 monster important decisions. Because I'm cruel like that, I'm going to put one at the top of the episode and the other at the very end. Also, the Supreme Court effectively sanctioned the termination of parole for like 500,000 people without explanation. And our law firm's challenge, with many other law firms, to the termination of temporary protected status for Haiti went to oral argument on Secretary Noem's early termination of TPS for Haiti, where our co-counsel did a fabulous job. Decision expected in June. Okay, long week here. So I will simply acknowledge the podcast patrons and thank them from the bottom of my heart, yet again for all their support. And I will state that I hope to speak with all of you at the AILA National Conference in Denver, coming up soon. And with that, on with the show. First up is Castaneira v. Noem, published by the D.C. Circuit on May 30th, 2025. This case is about the Walsh Act. It involves an issue very similar to one litigated by our firm many years back, which, in our opinion, nearly resulted in a win. Here, Mr. Castaneira got that win, or something very close to it. Let me explain. Mr. Castaneira is a United States citizen. He's married to a woman from Mexico and wants to live with her in the United States, as married people are apt to want. So he filed the Form I-130 petition for her, the first step to getting her a green card. No one's arguing that they don't have a valid marriage. But Mr. Castaneira has a problem. He, a U.S. citizen, has a conviction in Georgia for criminal attempt to commit child molestation, criminal attempt to entice a child for indecent purposes, computer pornography and child exploitation, and obscene internet contact. Looks like he was talking to a cop who he thought was 15 years old. He got 10 years and is a sex offender. But what does any of that have to do with his attempt to live with his adult wife in the United States? Well, the Walsh Act prevents a U.S. citizen from obtaining permanent resident status for a non-citizen relative if the citizen petitioner, quote, has been convicted of a specified offense against a minor, end quote. That latter phrase includes, quote, solicitation to engage in sexual conduct, end quote, and a lot of other things, including a catch-all provision that reads, quote, any conduct that by its nature is a sex offense against a minor, end quote. Why would Congress create such a rule targeting U.S. citizens? Well, I could be wrong, but I believe it was designed to make sure that sexual predators weren't able to petition for children or people with children that they could then sexually abuse. But adult spouses? I mean, I'm no psychologist, but I would think that even assuming the worst kind of sexual type disorder, if someone is a sexual danger to children, having an adult spouse with them would only be a benefit to everyone, right? Congress seems to agree, and so has a carve-out. DHS can still approve an I-130 if, in DHS's, quote, sole and unreviewable discretion, determines that the citizen poses no risk, end quote, to the non-citizen beneficiary. USCIS is the one that makes this determination. So here, whether Mr. Castaneira is no risk to his adult non-citizen wife. Congress wrote a really broad law with the Walsh Act, though. Dare I say an example of how not to write a law? Because, for example, it, quote, does not specify how that determination is to be made, including the applicable evidentiary standard pursuant to which the petitioner must demonstrate that he poses no risk, end quote. A gap that USCIS has taken to mean that it can do whatever it wants and not be reviewed by a federal court. In our case, for example, the government conceded during oral argument that, if USCIS wanted to, it could simply deny all such petitions based on a policy that every petition reviewed on a Wednesday will be denied, and a federal court could then never review that decision. And the government won. More on point here, though, in 2007, and left to its own devices on standards, a USCIS memorandum instructs that, quote, the petitioner must submit evidence of rehabilitation that clearly demonstrates, beyond any reasonable doubt, that he or she poses no risk to the safety and well-being of the beneficiary, including any alien derivative beneficiary, i.e., alien children of the spouse, in an I-130 petition, end quote. USCIS just made up the beyond a reasonable doubt standard. But here's the thing. The AAO's 2010 Precedential Decision, matter of Chawathe, holds that, quote, except where a different standard is specified by law, a petitioner or applicant in administrative immigration proceedings must prove by a preponderance of evidence that he or she is eligible for the benefits sought, end quote. Pretty clear then, right? The Walsh Act didn't list a standard. Chawathe says that means we assume it's a preponderance of the evidence standard, 51%. But USCIS simply made up in a memorandum their own standard and made it a nearly impossible to meet one, beyond a reasonable doubt. And yet, unless I'm mistaken, an argument similar to Mr. Castaneira's has lost in every circuit it's been brought. But not here, and arguably in the most important of all the circuits. Mr. Castaneira sued when USCIS denied his petition for his wife based on the Walsh Act no-risk thing. By the way, it doesn't seem like there's any children at issue at all. At least they're not listed in this decision. Mr. Castaneira lost and appealed to the D.C. Circuit. First, the D.C. Circuit held that yes, the Georgia conviction is of the type covered as an offense against a minor. Congress's use of the phrase, quote, any conduct, end quote, is clearly broad and expansive, and there's even a residual clause, remember? Even if an actual minor isn't involved, like here, the attempt is good enough to be covered. And even assuming the categorical approach applies to the inquiry, and the D.C. Circuit is skeptical, the Georgia attempt statute here meets it. That means we're in Walsh territory, and we're on to the exception. Whether Mr. Castaneira can show that there's no risk to his wife of bringing her here. That's the exciting stuff, right? Let's be real, if you're a nerd. On the no-risk thing, Mr. Castaneira submitted evidence, including reports from physicians, but USCIS denied, based on a finding that he, quote, still had recidivist risk factors that had to be monitored so as to avoid leading back into his offense cycle, end quote. And I'm sorry again, but if that's the case, shouldn't that counsel otherwise? Even assuming it's true, shouldn't we as a society want him to have an adult spouse with him at all times? I really don't get it. But anyway, USCIS held that he hadn't met the beyond a reasonable doubt standard. But is that the right standard? Well, held the D.C. Circuit, the district court was wrong to dismiss the matter of Chawathe-based argument, that is, whether USCIS applied the correct standard. Quote, if there is binding agency precedent applicable here, challenges to the agency's departure from its own precedent are judicially reviewable, end quote. Even though the D.C. Circuit states flat out that an ultimate no-risk determination is clearly not reviewable by a federal court because it's so dang discretionary, whether the agency applied the correct standard is reviewable. Quote, in other words, the issue before us is whether the statute, in granting USCIS sole and unreviewable discretion to determine that the citizen poses no risk, also affords the agency discretion to depart from its own binding regulations or precedents in making its determination. We hold that it does not, end quote. And that, my friends, is a big deal. Chawathe is binding agency precedent, end quote. Appellant contends that because Chawathe supplies the applicable evidentiary standard, USCIS's divergent from that standard was arbitrary and capricious. The government offers no intelligible answer, end quote. Can I get an LOL? This is a practices and procedures issue, that is, whether the preponderance of the evidence standard applies to the Walsh Act no-risk analysis. Federal courts can review it. Going all the way back to Ira's Supreme Court when in McNary, and additionally, citing to Judge Jordan's dissent in our Bourdon loss a few years ago on the issue in the 11th. In so holding, the D.C. Circuit full-on splits with the 8th Circuit, and in material parts on jurisdiction reviewability with the 3rd, 9th, 6th, and 11th Circuits. But the D.C. Circuit is just not having it. Quote, if Chawathe applies here, the agency has cabined its own discretion through its own precedent, and it must exercise its discretion in the manner it itself sets out, end quote. The D.C. Circuit doesn't know whether Chawathe applies or not, which is unfortunate. It wants the district court to determine that question first, so it sent the matter back. Still, a big deal. So, congratulations, Mr. Castaneira, who the decision lists as pro se and having literally argued his own case in court, and also Cameron Beach, student counsel appointed by the court, who argued the cause as amicus in support of appellant. With her on briefs were J. Scott Ballinger, Lori Albino McGill, and Catherine E. Stetson, also appointed by the court, with Lauren Emmerich and Benjamin Lennard, all, it seems, from the University of Virginia School of Law Appellate Litigation Clinic. What a win. And that is Castaneira v. Noem. Moving to the agency itself. Matter of Beltrand-Rodriguez, published by the BIA. Having read this on Tuesday, I wrote, another week, another 2 decisions from the BIA issued against the non-citizen that were once not precedential, but that the Attorney General or her designee has decided to make precedential. We're getting a bit more information on the process here, though. This and the next decision I'm about to do were done pursuant to actual Attorney General orders, dated May 23, 2025. I wonder if those other ones that have been designated were as well. I'm also curious what the orders actually say, or again, how the Attorney General is becoming aware of and choosing these specific decisions. Also, not for nothing, but here the Attorney General has decided to make precedential a decision in which the non-citizen did not file an opposing brief. This case is about bond. An immigration judge ordered one for Mr. Beltrand-Rodriguez in the nothing-to-snip at amount of $10,000 with conditions. DHS appealed, and applying de novo review, the BIA reversed, meaning that I suppose Mr. Beltrand-Rodriguez is returning to ICE detention if he ever left. Watch out! Quote, whether a non-citizen poses a danger to the community upon release or is a flight risk are questions of judgment that we review de novo, but the factual findings underlying such judgments are reviewed for clear error, end quote. The facts here, explains the BIA, show that Mr. Beltrand-Rodriguez was recently convicted of lewd or lascivious acts with a minor under the age of 14 in violation of Section 288A of the California Penal Code, for which he was sentenced to 365 in county jail and 4 years of probation. He was also convicted of the offense of sending harmful matter to a minor in violation of Section 288.282 of the Cal Penal Code, and he received a suspended sentence. He also must register as a sex offender for 10 years. Seems like he kissed his 12-year-old half-sister, quote, several times, and sent her sexually explicit photographs of himself and videos of him engaging in sexual conduct, end quote. But also, there was no other evidence that Mr. Beltrand-Rodriguez had ever done anything like that before, or that he'd violate the criminal court order. And right at the end of the day, the criminal court didn't sentence him too harshly, particularly given that the maximum sentence was 11 years in prison. The decision doesn't say anything about Mr. Beltrand-Rodriguez's character. And very importantly, DHS had the burden here, which might no longer be the case after the Supreme Court's Jennings decision, but also I believe that things are still different to the Central District of California. It's confusing, everybody. But burdens matter. Seems like DHS had only the conviction to meet their burden here. It was enough, said the BIA. Quote, the respondent's behavior was dangerous and subjected a person who was particularly vulnerable because of her age and her familial relationship to the respondent to unlawful sexual conduct, end quote. That is the entirety of the BIA's analysis, overturning what appears to be a thought-out decision from the immigration judge. Meaning, Mr. Beltrand-Rodriguez remains in or returns to custody. But I don't know, y'all. These recent BIA bond decisions seem to focus on somewhat extreme examples of criminal conduct. I think that many practitioners can put forth a persuasive effort to distinguish their bond case from these facts. In fact, I did that just last week. Didn't work, as individuals listening to this podcast may know, but I respectfully believe that we had the better argument. Keep fighting. And that is matter of Beltrand-Rodriguez. Next is matter of Bain, published by the BIA. As I mentioned, this is another one designated by the Attorney General pursuant to a mysterious order. This one's about cancellation of removal and discretion. In this case, the Attorney General had the BIA designate as precedential a decision where the non-citizen was representing himself. An immigration judge granted Mr. Bain this not easy form of relief, that is, non-LPR cancellation of removal, permitting him to remain in the United States with his U.S. citizen family. The BIA reversed on DHS's appeal. Because even with exceptional, extremely unusual hardship shown, explains the BIA, quote, as negative discretionary factors grow more serious, the respondent must show offsetting favorable factors, which in some cases may have to involve unusual or outstanding equities, end quote. And again, exercising de novo review, explains the BIA. Here, quote, the respondent became homeless in 2018 or 2019 and would panhandle during periods of unemployment to help pay for his child support. The respondent only filed taxes once and was unemployed during parts of the COVID pandemic, end quote. I suppose more importantly, Mr. Bain has a criminal history over an 8-year period through 2023 in Florida. Who doesn't? Most of it drug-related. And the BIA explains that there is no evidence of rehabilitation in prison. On the other hand, Mr. Bain has lived in the United States for 27 years, beginning as a young child. He grew up in America, has been a lawful permanent resident since 2011, and worked as a carpenter and other jobs before becoming homeless. Quote, we recognize that the respondent expressed the desire to better himself and misses his family and children. However, the record does not support that the respondent has sufficiently demonstrated rehabilitation, particularly in light of his past drug-related criminal activity, end quote. And though somewhat unelaborated on in this decision, quote, the equities and humanitarian factors present in this case are not insignificant. The respondent's criminal record is, however, recent, serious, and recidivist, end quote. So, considering its recency and repeated nature, another thing absent in most cases, the BIA held that Mr. Bain did not warrant relief as a matter of discretion and overturned the immigration judge. I am curious, though. Is there any support out there for the argument that the adverse factors must be particularly high when a non-citizen's removal will result in exceptional and extremely unusual hardship to a qualifying relative, as I believe was the case here? I feel like there might be. There definitely is in the asylum context, because of what a well-founded fear of persecution represents. The standard to deny asylum as a matter of discretion is particularly high. Similar with non-LPR cancellation? Certainly not discussed by the BIA in this decision, so maybe the case doesn't exist. But even if it doesn't, make that argument, I say. It makes logical sense to me. Someone send me the case law. And that is matter of Bain. Next is matter of DEB, published by the BIA. We're moving on to the BIA's Wednesday publications. Two more that the Attorney General reached down to make precedential. I've lost count of how many at this point, and I'm beginning to suspect that the Attorney General wishes to kill me. I fear that if this becomes the norm, I will unwittingly, or wittingly, because I'm literally wittingly saying it, simply become a mouthpiece for the Attorney General's desire on immigration. To be determined. And can we all please pause for a moment to reflect on how much the former Attorney General could have done but chose not to do, as evidenced by this onslaught of publications intended to shape immigration law in the direction of the current administration. And we haven't even arrived at the official Attorney General publications yet. They're coming. So, this one's about motions to reopen. Mr. DEB, an acronym, is from Jamaica, had a non-LPR cancellation of removal application denied by an immigration judge, and that was affirmed by the BIA. He then filed a motion to reopen. To succeed on a motion to reopen, a non-citizen must make a, quote, showing of prima facie eligibility for relief and the proffer of material evidence that was unavailable and could not have been discovered or presented at the former hearing, end quote. As the basis for this motion, filed a few months after the BIA affirmed denial of his application in 2021, Mr. DEB argued that new and previously unavailable evidence shows that, quote, 1, his counsel before the IJ offered ineffective assistance, 2, he has a qualifying relative for purposes of cancellation of removal, and 3, he is prima facie eligible for relief under the Violence Against Women Act due to spousal abuse occurring after his merits hearing, end quote. He has a U.S. citizen daughter. And again, this motion to reopen was filed in October 2021. So a long time ago. As such, it was actually a timely motion to reopen. And it also requested a remand so an IJ could consider an adjustment of status application based on Mr. DEB's marriage to what appears to be his longtime, often on-again U.S. citizen partner. A few years after that, with the motion still pending, Mr. DEB supplemented the record to request adjustment of status based on the VAWA due to abuse he claimed he suffered in that marriage. He submitted the USCIS prima facie eligibility notice and everything later on. Here, the BIA denied the motion to reopen. First, on ineffective assistance of counsel. There were lots of claims made against former counsel. This case arises in the Third Circuit, which, according to the BIA, does not require strict compliance with matter of Lozada, including a draconian and at times suicide-inducing requirement that a non-citizen file a bar complaint against the attorney that they allege has committed ineffective assistance of counsel. According to the BIA, the 2008 Third Circuit decision Rancy v. Attorney General of the United States stands for the proposition that a non-citizen need not file the bar complaint, quote, as long as the respondent fulfills the purpose behind those steps through substantial compliance, end quote. What does that mean? I'm personally not entirely clear, which is what makes matter of Lozada so dangerous. But as the BIA explains, Mr. DEB didn't file a bar complaint or adequately explain why he did not do so. Now, his wife did indeed write to disciplinary counsel about the former attorney, and the respondent himself is, quote, illiterate, end quote. And yet still, explains the BIA, the lack of evidence of Mr. DEB's involvement in the disciplinary complaint filed by his wife, who he is now alleging abused him, will be held against Mr. DEB. Also explains the BIA, Mr. DEB did submit an affidavit with his motion, likely with the assistance of new counsel, and it makes allegations beyond those of his allegedly abusive wife against former counsel. What a mess. Plus explains the BIA, disciplinary counsel, I guess with New Jersey, emailed Mr. DEB's counsel for additional evidence, and the record does not show that current counsel provided it or what happened next. According to the BIA, quote, a central purpose of the bar complaint requirement is to allow disciplinary authorities to assess whether a pattern of attorney misconduct exists and needs to be addressed, end quote. And only in immigration, and literally in no other area of law, is this required for a victim of ineffective assistance to possibly get some relief. But, considering this apparent purpose, Mr. DEB and his current attorney's failure to, quote, adequately explain whether he aided in this purpose, end quote, is fatal. Notwithstanding the Third Circuit's no strict Lozada compliance rule. Meaning here, no ineffective assistance of counsel-based motion to reopen will be granted. Turning to the new evidence submitted in support of non-LPR cancellation of removal, the only new evidence according to the BIA is, quote, a paternity test dated July 30th, 2021, establishing that he is the biological father of his United States citizen daughter, end quote. Seems that the original qualifying relative was probably his wife then and not his daughter. But now, so the argument goes, he has another qualifying relative to suffer the hardship? Actually not. Wouldn't likely change the results according to the BIA, because the IJ apparently did consider father-daughter separation, I suppose assuming in fact that he was the child's father. Not to mention the IJ also denied as a matter of discretion, and Mr. DEB's motion apparently does not address that or contain new material evidence on that element. Finally, the VAWA. No number bars on motions to reopen if they're VAWA-based, so he's got that going for him, explains the BIA. But the statute does say that such motions are supposed to be filed within 1 year of the final administrative order, which here was in 2021. Recall, Mr. DEB did timely file a motion to reopen in 2021. But only after that, in 2023, did he file the VAWA portion. So that's over 1 year post-2021 final BIA order. Seems like Mr. DEB's counsel was smart, tried to get around that by labeling the 2023 filing a supplement. But it's a totally different motion to the BIA in actuality. As such, the BIA found that supplement, which is really a motion to reopen for the VAWA, untimely, filed over 1 year post-final order. Now, the BIA always has sua sponte authority, even if it doesn't mention it in this decision, and additionally, it can extend the 1 year deadline based on a showing of extraordinary circumstances or an extreme hardship showing to the VAWA applicant's child. But even still, and a bit of a theme from the BIA that IJs have been telling me since I was an attorney advisor, almost all forms of relief are discretionary, and that includes VAWA cancellation or VAWA adjustment. And recall, the BIA doesn't think Mr. DEB has presented new and previously unavailable material evidence on discretion. This is particularly the case where there was evidence before the IJ, quote, regarding his conviction for harassment, which shows he intimidated the victim by brandishing a foot-long butcher's knife, end quote. Concluding that Mr. DEB will be subjected to a $998 a day fine if he fails to depart, the BIA denied Mr. DEB's multi-issue motion. MIM. Here's a footnote-based observation. In a footnote, the BIA says this about what is likely Mr. DEB's counsel's reliance on Ben Winograd's unpublished BIA decision log. Quote, we note the respondent cites several unpublished board decisions to support his arguments. These decisions are not binding precedent and are premised on specific factual scenarios which are unavailable for review and pertinent only to the respondents described therein, end quote. The BIA is sick of you, Ben Winograd. And I'm not sure all circuits agree there, though, especially the First Circuit. Yes, of course, unpublished BIA decisions aren't binding, but if they show a settled practice that the BIA deviated from in a given case, the non-citizen has a claim based in administrative law. It's a viable argument and probably why counsel submitted the decisions, BIA footnote notwithstanding. Always be playing for the next level of appeal. Finally, saying the implicit part out loud here, if your client, like Mr. DEB, has a long pending motion to reopen that might have been granted by the BIA during the last administration, this case seems like a bit of a shot across the bow. Prepare for more denials, or supplement your long pending motions heavily with new and previously unavailable material evidence if you've got it while you still can. And that is a matter of DEB. Next is matter of NNB, published by the BIA. Another one designated by the Attorney General. This one is about Convention Against Torture Deferral, and it's another one reversing the immigration judge. I must admit, I do not recall many precedential reversals of IJs that were adverse to non-citizens during the last administration, but I could be misremembering. And certainly not in the first 4 months of the Biden administration. Curious. Mr. NMB is from Russia and apparently testified that he would refuse to join the military in that country. I imagine related to the war in Ukraine? Unclear. In exceptionally cursory fashion, the BIA reversed the IJ because the IJ apparently based its finding on the fact that Mr. NMB, quote, could be, end quote, tortured in Russia, rather than using the language, quote, more likely than not, end quote, which of course is the CAT standard. Don't know if the IJ's decision as a whole made clear that the IJ did in fact apply the right standard, but the BIA is convinced that the IJ did not. Though even if the IJ had, explains the BIA, it doesn't see a CAT case, exercising, you guessed it, de novo review. Quote, the immigration judge concluded that the Russian government would torture the respondent for not joining the military after receiving 2 written notices of conscription, failing to report, and receiving a visit from 2 men who threatened him with forced labor if he did not report. However, this is based on a series of suppositions, end quote. Isn't literally everything, though, when trying to predict the future, which is what CAT is all about? Everything is a supposition if it hasn't happened yet. The problem to the BIA is that Mr. NNB apparently didn't actually know what would happen to him if he refused to join, I guess with near enough certainty. I'm sure he has some idea as a Russian, but not clear enough to the BIA. Turning to the country conditions, which can shed further light on such suppositions. Yes, indeed, there is evidence to support, but not enough. And here appears to maybe be the meat of the issue. Mr. NMB is 59 years old, and the conscription evidence appears to regard men in their 20s and 30s, tops. Further distinguishing some other country condition evidence from Mr. NMB's case, the BIA denied. So, not to sound like a broken record, but a case decently distinguishable from other Russian forced conscription cases, given the BIA's very brief analysis and the fact that the respondent is 59 years old. But additionally, and maybe putting Mr. NMB somewhat to the side, I see this as just another decision confirming that it is becoming nearly impossible to win a CAT case without an expert witness. I can't imagine that was Congress's intent when they signed on to the treaty, but who knows? Anyone want to do the research? And that is a matter of NNB. Finally, from the agency, we have a matter of Lopez-Ticas, published by the BIA. A decision not designated by the Attorney General, but issued by the BIA itself on its own decision. Looks like the BIA is trying to kill me too. Just know, BIA, if you succeed, I will return to haunt the halls of 5107 Leesburg Pike in Falls Church. I will literally never leave. I will reside there and spend the majority of my time in the C-level suites, but will also terrorize the attorney advisors and staff from time to time. I will also learn how to use the pens and grant every reasonable request that comes to the clerk's office. Dozens of careers will be ruined. You've been warned. Publish accordingly. Doubling down on what is a clear attempt to murder me, this case is about deficient notices to appear. Again, overturning the immigration judge. The NTA in this case lacked the date and time of the initial master calendar hearing in clear violation of I&A Section 239A. Looks like it was served just before the Pereira decision was issued by the Supreme Court in 2018, when this whole argument exploded. The next year, the respondent admitted the factual allegations in the NTA and conceded removability. But in 2021, the respondent moved to terminate. After all, in the interim, the Chavez had been issued by the Supreme Court, making quite clear that notices of hearing don't clean up deficient NTAs. But all of that is, of course, in the stop time rule context for non-LPR cancellation of removal and probably voluntary departure. Just what to do about deficient NTAs in the removal proceedings in chief remains a bit open today, and certainly was in October 2021 when termination was moved for. And IJ granted the motion to terminate, that is. DHS appealed. The BIA remanded, relying on then the quite new matter of Fernandez decision, which did seem to sanction termination, but also seemed to indicate that asserting a deficient NTA claims processing rule violation wasn't timely if not raised before the close of pleadings. Quote, the board also concluded that the immigration judge erred in finding that Ms. Chavez represented a change in law that warranted termination of the proceedings. End quote. But I mean, come on, BIA, with that last holding and the procedural history of this case. We all know the precedent you were issuing before Ms. Chavez and how that decision changed so many things you were doing. But whatever. You do you. On remand, Mr. Lopez-Ticas moved to withdraw his pleadings and renewed his termination motion. The IJ granted it. After all, now pleadings had not closed. Quote, alternatively, the IJ found that the holding in the matter of Fernandez regarding the timeliness of an objection to a non-compliant NTA should not be applied retroactively, end quote. So, oh boy, here we go. DHS appealed again, and the BIA has now sustained that appeal again, exercising its de novo review in a manner I swear it has now done more times than it did during the entire last administration. Quote, respondents are bound by the concessions of their attorneys unless they can show egregious circumstances, end quote, begins the BIA. To the BIA, quoting itself, that requires a showing that the factual admissions or concessions are actually untrue or incorrect. Only after that showing is made, explains the BIA, quoting itself, can a non-citizen be relieved of his or her counsel's concessions or admissions, but only then if, quote, the result of unreasonable professional judgment or where binding the non-citizen to the admission would produce an unjust result, end quote. Finally and importantly here, quote, an intervening change in law, end quote, can satisfy that second prong, that is the unjust result thing. Here, the BIA held that the IJ erred in permitting Mr. Lopez-Ticas to withdraw his pleadings in the first place. First, on a pretty unique technicality, but more importantly, concession of proper service of the NTA, even if erroneous because it's not a proper NTA, is not the kind of untrue concession that could warrant repleading. The BIA is requiring a showing that the actual factual allegations or charge of removability that were admitted and conceded to are untrue to permit withdrawal of a pleading to an NTA. Here, Mr. Lopez-Ticas didn't make such showing because it probably can't be made. It seems like Mr. Lopez-Ticas was arguing primarily that the prior concession to proper service was the untrue thing, because again, it's not really an NTA under I&A Section 239A. But of course, that's a broad reading of Section 239A. And more importantly, quote, service of the respondent's NTA was proper, regardless of whether it contained the time and place information. That the notice to appear was missing the date and time of the hearing does not render service of the document deficient, end quote. The BIA states, quote, the lack of time and place information on the NTA does not render untrue or incorrect a respondent's admission to the factual allegations or invalidate the charges of removability in the NTA, and therefore is not a proper basis for granting a respondent's motion to withdraw pleadings, end quote. By the way, explains BIA in footnote, not challenging a defective NTA isn't grounds for ineffective assistance of counsel, as it is a reasonable, tactical decision. So, there were no grounds to withdraw the pleadings to the BIA. Meaning to the BIA that again, under matter Fernandez, the motion to terminate for the defects in the NTA was an untimely motion, given that it was made after pleadings had been taken. Which then gets us to the final argument, Can matter of Fernandez's prior to pleadings rule be applied retroactively to pleadings that were taken pre-Fernandez? It can. Explain the BIA. Because it already said so in matter of Larios Gutierrez de Pablo and Pablo Larios, which hadn't been issued when the IJ ruled in this decision, and which I had admittingly already forgotten about because there are just so many. Episode 239. Neither the Fernandez rule nor Ms. Chavez to the BIA is a sufficient change in law that warrants terminating proceedings or excusing procedural rules, meaning that this case goes back to the IJ for a third round of proceedings. And that is matter of Lopez-Ticas. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Rejoice! We are out of the agency decisions. With Sarkisov v. Bondi, published by the 6th Circuit on May 29th, 2025. This is a very short case about stays of removal. Mr. Sarkisov was ordered removed, filed a motion to reopen 6 years later, had that denied, and appealed. The BIA denied that. He then went to the 6th Circuit with the denial and additionally asked the 6th Circuit to stay his physical removal while the 6th Circuit considered his petition for review in chief. The 6th Circuit has now declined to do so. The Nicken factors, the Supreme Court's, that is. Last discussed against the government in the 2nd Circuit habeas cases from episode 263, if I'm not mistaken. Recall, no matter what party is seeking a stay of what a lower court has ordered, quote, to justify that burden, the applicant must show, among other factors, 1, that he is likely to succeed on the merits of his underlying appeal, and 2, that he will be irreparably injured without a stay. These 2 factors are the most critical. Only once an applicant satisfies the first 2 factors does the court assess 3, the harm to the opposing party, and 4, weigh the public interest, end quote. By the way, it was all of this that the dissent in the parole case had a big issue with. That is, the government not having satisfied prong 1 or prong 2. Back to the 6th Circuit, where the non-citizen had the burden. Quote, these last 2 factors merge into a single inquiry when the government is the opposing party, end quote. That is, the harm to the opposing party and the public interest. Noting it was only a 2-page stay motion, the 6th Circuit held that Mr. Sarkisov didn't satisfy the standard, in particular because his motion, quote, doesn't say anything at all about the merits, end quote. And let's be honest, that's the most important Nicken factor. Nor does he discuss the irreparable harm prong, which, let's be honest, is a close second in importance. Other than saying succinctly, according to the court, that he will suffer irreparable harm absent a stay, which does not suffice. All the more so because since after IRIRA, quote, litigants like Mr. Sarkisov are now free to continue pursuing their appeals from abroad if they are deported while the appeal is pending, end quote. That means that, quote, the burden of removal alone cannot constitute the requisite irreparable injury, end quote. That's a bit of a double-edged sword law there for sure. All of this requires denial of the stay motion, explains the 6th Circuit. But not for nothing, quote, there is always a public interest in prompt execution of removal orders, end quote, the last 2 Nicken factors. Even if here the government didn't oppose the stay motion, which might explain the bare-bones nature of the motion, eek. Is not the position of the opposing party significant? Not enough, explains the court, where Mr. Sarkisov has the burden. At the end of the day, explains the court, whether to grant a stay is up to the court, no matter what the government wants or doesn't want to do. Remember that and file your motions accordingly. And here, the stay was denied. And that is Sarkisa v. Bondi. Moving on to Hamilton v. U.S. Attorney General, published by the 11th Circuit on May 29, 2025. This case is about motions to reopen and lots of things, including, deficient notices to appear. Mr. Hamilton is from Jamaica and was a lawful permanent resident. But in 2014, he was convicted of aggravated battery with a deadly weapon in violation of Florida Statute Section 784.045 1A2. DHS alleged that this was a CIMT committed within 5 years of him receiving LPR status and succeeded because the 11th Circuit said it was a CIMT 20 years ago. But the NTA that kicked the removal proceedings off lacked the date and time and the location of Mr. Hamilton's first removal hearing. It was deficient, but that was 2015. By 2017, although he had married a U.S. citizen, he missed his deadline to file for adjustment of status or any other relief ordered by the IJ, and so was ordered removed. Jump-started by all that, it seems, his wife filed an I-130 petition for Mr. Hamilton 4 days later, and 5 days after the removal order, he filed a motion to reopen on that basis. Mr. Hamilton did not include an application for relief with his motion, DHS opposed the motion, and the motion was denied. To be fair, he wasn't eligible for adjustment of status yet, right? The I-130 was still pending. Shortly thereafter, Mr. Hamilton filed a second motion to reopen, attached an asylum application, and attached a copy of the pending I-130 petition. DHS opposed again. And well, you generally only get one motion to reopen, so the IJ denied. The asylum application wasn't based on new evidence according to the IJ, and the IJ held that Mr. Hamilton wasn't prima facie eligible to adjust because he hadn't shown that he wasn't unlikely to become a public charge. Remember when that was all the rage during the first Trump administration? Denying things based on a public charge finding? It's coming back, y'all. Mark my words. The BIA affirmed this second denial of a motion to reopen. Meanwhile, the I-130 was approved, and Mr. Hamilton petitioned for review the second motion to reopen denial, making a deficient NTA argument which the 11th Circuit rejected by unpublished decision. Then, Mr. Hamilton filed a third motion to reopen based on the approved I-130, arguing he should be permitted to apply to adjust with a Section 212H waiver for his CIMT. And IJ and the BIA did not agree. And here's where it gets interesting, if you're not already riveted. LPRs can't apply to readjust with a Section 212H waiver of their CIMT inadmissibility unless they've, quote, lawfully resided continuously in the United States for a period of not less than 7 years, immediately preceding the date of initiation of proceedings, to remove the non-citizen from the United States, end quote. Mr. Hamilton argued that after the then recently issued Chavez decisions, his proceedings were never properly initiated for Section 212H purposes because the NTA didn't comply with INA Section 239A. Like the cancellation of removal stop time rule, he argued that Section 212H's continuous residence stop time rule was never triggered. Interesting. A motion rejected by the agency is numerically and time barred. That is, the motion to reopen. And the 11th Circuit affirmed. First, it did not agree that Ms. Chavez permitted equitable tolling of the 90-day deadline to file a motion to reopen. And the court took up his argument on the merits after that. The stop time rule for cancellation and Section 212H are not the same, explained the 11th Circuit. The former expressly references Section 239A. That's the whole gist of Pereira and Ms. Chavez, explains the court. The latter, Section 212H, does not. Aha, argued Mr. Hamilton. Section 239A is literally titled, quote, initiation of removal proceedings, end quote, which is almost the exact phrase used at Section 212H. No dice. Section headings aren't overly important, explains the 11th Circuit. Section 239A says a lot of things, and, quote, nothing in Section 239 requires that removal proceedings can only be initiated by issuing a compliant NTA, end quote. 1996 dictionaries support a broader meaning of the phrase initiating proceedings. Proceedings that, as a matter of fact, have indeed gone quite far in this case. were, after all, on the third motion to reopen, reasoned to the court. Plus, the Capo Chavez decision from the Supreme Court last term, and a couple of other arguments were rejected as well. Interesting stuff, though, if you're not sick of the deficient NTA saga that this podcast has taken you down over the years. Nor did the 11th Circuit see the BIA's analysis on these issues as reversibly deficient. The BIA gave enough reasoned consideration. It discussed Ms. Chavez and its relationship to Section 212H, for example. It was enough. As such, the 11th Circuit denied the petition. Interesting arguments, though. And that is Hamilton v. U.S. Attorney General. Do not throw away your shot. We've reached the end. I promised you we would. And it's a good one. Peterson et al. The Department of State et al., published by the D.C. Circuit on May 30th, 2025. This case is about consular review and suing the Department of State. Judge Pan dissented. Mr. Brown is a U.S. citizen. He wants to marry a foreign national and live with her in the United States. Sound familiar? That person is Miss Peterson from the Netherlands. Why the issue? Well, Miss Peterson had previously entered the U.S. through the visa waiver program multiple times. Totally allowed for Dutch people, and would, quote, occasionally assist a friend and colleague with horse riding clinics in Utah and receive nominal compensation in exchange for her assistance, end quote. Because of that, the U.S. government wants to split up an American from his spouse, potentially, forever. Because visa waiver people aren't allowed to work. The consulate has now since denied her multiple K-1 visas to come to the United States and get married to Mr. Brown for this reason and this reason only. Wild, right? I don't know, I find it wild. Does the Department of State know how hard it is for an American to learn Dutch? So the couple sued in federal court, where they ran headfirst into the doctrine of consular non-reviewability. And yet they have succeeded at the D.C. Circuit. Not on the doctrine of consular non-reviewability per se, or the previous denial of K-1 visas. Those can't be challenged and weren't ultimately challenged here. Rather, the couple argued that the consulate was applying the wrong, quote, reason to believe, end quote, standard to determine fraud and inadmissibility, and alleged that the Department of State has shown that they will again erroneously apply that standard in future applications. And with that argument, the couple got around the doctrine of consular non-reviewability. Should I say that again? And with that argument, the couple got around the doctrine of consular non-reviewability. Quote, when plaintiffs launch forward-looking challenges to the lawfulness of regulations or policy governing consular decisions, courts may review them to ensure that the executive departments abide by the legislatively mandated procedures, end quote. Oh my. Plus, the D.C. Circuit majority here doesn't seem very pleased with how the Department of State is conducting itself. Now, we all know that non-citizens are inadmissible if they have tried to or succeeded in getting a visa or other immigration benefit by fraud or willful misrepresentation in the past. And then there's the dreaded Section 201G letter, whereby, quote, no visa shall be issued to a non-citizen if the consular officer knows or has reason to believe that such non-citizen is ineligible to receive a visa or such other documentation under Section 212 of the INA or any other provision of law, end quote. The Department of State's Bible, the FAM, in turn directs that to make such a finding, quote, a consular officer must make a finding that there is direct or circumstantial evidence sufficient to meet the reason to believe standard, which requires more than mere suspicion and is akin to probable cause, end quote. So, back to Miss Peterson. She did do the horse thing for a friend and I guess did get a little money while she was here on her visa waiver. Lord forgive her. The U.S. government learned about it all by looking through her social media, or maybe the social media of the horse place, by the way. They denied the visas by citing to the fraud statute, INA Section 212A6CI. The couple sued on the last K-1 denial and again on the foreseeable harm of future K-1 denials. First, explains the court, the couple has standing. Their asserted injury of a future denial isn't overly speculative. Quote, Mr. Brown is suffering an ongoing injury from the exclusion of his fiancée, Ms. Peterson, from entering the United States. Importantly, the Supreme Court has recognized that an American citizen who has a bona fide relationship with a particular person seeking to enter the country can legitimately claim concrete injury if that person is excluded, end quote. To be very clear, concrete injury for standing purposes is a bit distinct from whether there is a constitutional right that can get around the doctrine of consular non-reviewability, which I believe was at issue in Munoz. Really walking a fine line here, but a successful one. Also, to the Supreme Court, the couple have plausibly alleged that the Department of State is going to rely on their understanding of the reason to believe fraud standard to deny again in the future. So, standing. Okay. What's happening here is the couple is arguing that the FAM is violating the law. It is improperly telling, quote, consular officers that they could find a non-citizen inadmissible based on such officers' mere reason to believe that such non-citizen had willfully misrepresented a material fact, when in fact, the statute requires a consular officer to find that the willful misrepresentation had in fact occurred, end quote. What an argument. An argument not barred by the doctrine of consular non-reviewability. Quote, it is well settled that when plaintiffs pursue forward-looking challenges to the lawfulness of regulations or policies governing consular decisions, courts may review them to assure that the executive departments abide by the legislatively mandated procedures, end quote. Kind of similar procedure type holding to the Walsh Act case that we did at the top from the D.C. Circuit. I don't think it's a coincidence that they were published on the same day. The couple here are challenging what they say will be the Department of State's future application of an unlawful legal policy. And that can survive even the harshest of review-stripping provisions, says the D.C. Circuit. So then on to the merits of that claim. Well, the district court really didn't engage with it, so the D.C. Circuit is sending it back. But not without some comments. Notably, there are inadmissibility provisions that literally have a reason to believe standard in the statute, like drug trafficking and admissibility. But the fraud and willful misrepresentation provisions aren't one of them. That requires an actual finding that fraud or willful misrepresentation has occurred. I'm convinced. The Department of State retorts that Section 201G itself has a reason to believe standard that then applies to all inadmissibility provisions and so allows visa denials based only on a reason to believe, always. Officers are essentially free to suspect what they want. Damn the evidence. The chutzpah. Quote, we are skeptical of this view, end quote. It's complicated, but summarized by the court, Section 201G, quote, seems to require a consular officer who suspects but has not yet verified that an inadmissibility determination has been made under Section 212A, and accordingly to the standard of proof specified therein, to withhold a visa on the ground until the alleged basis of ineligibility can be confirmed, end quote. The D.C. Circuit seems to believe that Section 201G is kind of like a holdover statute, but still requires that the consulate make an ultimate decision and that ultimate decision comply with the standard employed by the inadmissibility statute itself. Other arguments are relied on by the D.C. Circuit too, but it wants a district court to ultimately determine. Rejecting another argument about the FAM, the majority remanded. Judge Pan would not. But man, is it a long week. So good day. And congratulations on a big win to Carl W. Hamp, Daniel P. Pierce, and Daniel D. Schaefer. And that is Peterson et al. V. Department of State et al. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/immigration review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.